Good morning, everyone. Hi, Caroline. Welcome to Filing Trademarks with an Eye Towards Litigation. My name is Lauren Amanda. You should all know me by now, I hope. I'm the National Sales Director here at Alt Legal. As a quick reminder, just before we get started, code of conduct, use your common sense. Don't be a jerk. If anyone is violating this code of conduct, please let us know. If you're watching this session live, you may qualify for CLE credit. Very exciting. Keep in mind, we're keeping detailed attendance records, including both whether or not you're in the session and whether or not this is the active tab. So keep it active, chat with everybody, stay involved, and I'll come back in to announce a code at random time during the session. Please take note of the code on your survey. I'm going to try to repeat it since I keep forgetting to do that. And in order to qualify for CLE credit, you must be in the session the whole time and have the code. After the conference, we'll send out CLE information about the sessions that you've attended. And please note that our CLE provider is only providing credit for the live presentation, so if you're watching this recording, does not qualify. In terms of chat and Q&A, you're welcome to use the chat on whichever platform you're logged into. For questions and comments directed at Caroline, please use @presenter@Caroline. We'll make sure they get passed along. And this session has been brought to you by our very generous sponsor, Docket Alarm. They're awesome. Check them out. And now it's my pleasure to introduce our speaker, Caroline Fox. Caroline is based out of Richmond, Virginia. Her practice, CJFox Law, PLLC, includes representations of brands both large and small in the advertising, tech, and creative industries. Caroline has been recognized as a Virginia legal elite in intellectual property for the past 4 years and as a Superlawyers Rising Star for the past 2. And she holds a dear place in our heart. So with that, Caroline, I'm really excited. Feel free, get things started, kick things off. Like I said, I'll pop back in to provide that CLE code, but good luck. I'm excited.
Awesome. Thank you so much, Lauren. Thank you, everybody else at Alt Legal. You guys have actually put on an amazing virtual conference, which I was not expecting a virtual conference to be so fun, but I don't think I'm ever going to put on pants to go to a conference again because this was so great. So my name is Caroline Fox. Like she said, I am based in Virginia. I'm actually based in the Eastern District of Virginia, which is a rocket docket. So we move very quickly here and it's pretty intense. I am a big fan of protecting my clients' rights, but I'm not such a huge fan of litigation. So I am what I like to call a professional second chair, a professional sit in the back seat and advise while the arguers go and actually argue. I do a lot of writing. And over time, I have worked kind of behind the scenes on a lot of pieces of trademark litigation, pre-litigation, things of that nature. So what we all want to do as trademark lawyers, as a transactional lawyer and as a trademark lawyer, you really do want to protect your client from having to go into litigation. We don't want to have to deal with that for them. It's expensive. It's very stressful for both them and us. And, it's just, I feel like when we move into litigation, in the end, the winners are the lawyers. So over time, I've developed this kind of method for prepping and preparing trademark applications as to try and avoid that. And so that's what we're talking about today. So again, why should transactional attorneys care about this? Why, when we are the ones just hearing, get the trademark, get the trademark, get the trademark, get the registration. All I want to do is just get the registration. You're not serving your clients well if you're just going for a registration. And I know that in a time when we have things like the Amazon brand registry and DMCA takedowns and ICANN preference to trademark holders and dispute resolution that may not go all the way towards litigation, we may not be thinking that way. However, if you are positioning yourself as an expert and positioning yourself as a lawyer who is looking out for the brand's best interest and your client's best interest, these are things that we need to be thinking about. It's kind of like when you've got your training wheels, right? You're on the bike and you are pedaling really hard. You're moving, like you're able to file the trademarks. You're able to get the trademarks for your clients. But if you really want to do well and you really want to get on the road and start getting distance on your bike, you need to be able to look at these and look through these scenarios to serve your clients. So how do attorneys draft applications on the front end, whether it is before the trademark is being used in commerce and it's a 1B application, or maybe they've been using it in commerce for a little while, maybe they've been using it for a long time? How do we draft these applications to put our clients in the best possible scenario should litigation arise? Should litigation arise now or down the road? Maybe it's an opposition. You know, when I say litigation, maybe it is an opposition proceeding. Maybe we're going to be dealing with a cancellation proceeding. Maybe we know that when we go into this trademark application process, we are going to be filing for cancellation of a mark. Because maybe it's not in use anymore. Maybe we want to try to get rights to a mark. And if we get an office action, we are going to work towards cancellation of the mark that is actually filed and registered at this time. So when we say litigation, we're talking about all of those things. First thing we need to do is begin with the end in mind. We need to think about defenses that someone else in litigation may be using in litigation for an alleged trademark infringement, or maybe it's during a cancellation proceeding, or maybe it's during some sort of opposition proceeding. So I don't love civil procedure. I will say that it's not my favorite thing. I would much rather think about the brand protection, but I do work with people who love civil procedure. And I think that if you are not going to be actively litigating and actively involved in the litigation process, you need to at least find someone who can explain the civil procedure aspects to you. I know a lot about civil procedure now. Still don't love doing it, but it's very, very important to understand these, because when we are drafting our applications, we need to think about, okay, well, when I put this in writing or when I put this in this application, what is something that someone could say that's attacking this mark? We need to be moving through it thinking, all right, in a worst case scenario, where are my Swiss cheese holes? What can I do to plug up those holes in the bottom of my boat? So when we're thinking about infringement actions, some of those defenses look like standing, issue preclusion, maybe, or just preclusion, functionality, if it is being used in a functional way, fair use. A lot of infringement, people think that they are using it fairly. I actually had a TikTok go semi-viral recently about whether something was fair use or not. Whether it is a parody, that's also a very well-known exception to trademark infringement. And I will say, one of the first trademark infringement defense actions that I worked on, we ended up using a parody defense and things worked out fine. So First Amendment concerns also, there are a lot of people who may be utilizing First Amendment concerns, especially if it is in a political arena, or if you are representing somebody where there is some sort of social justice implication. We need to be thinking about that. Estoppel, which if you haven't done civil procedure in a while, just think back to the bar exam. Latches, waiver, and unclean hands. So these are all infringement defenses to think about. Now, if we are thinking again about cancellation proceedings, which are obviously different than infringement, but still in that litigation sphere, we need to be thinking about these sorts of defenses. Not defenses. These are the reasons that we or an opposing party may be asserting for cancellation. So if you are a mark holder or you are representing somebody and someone is filing a cancellation proceeding against you, or if you are filing a cancellation proceeding against somebody, these are some of the things that we would be thinking about. Obviously, defensively, if we are being filed against in a cancellation proceeding, these are a little bit, the ante's up a little bit. So abandonment, non-use. So for your clients, if they are going to be keeping these marks for a while, or they want to eventually revive marks, maybe not revive in the sense where we are reviving dead marks from the USPTO, but maybe they're not using it necessarily as much as they should have been, or maybe they have not, they are kind of bringing back from the dead a brand that may have been a little bit dormant for a while. We need to think about why that non-use existed and if it's excusable. An example of this is actually my college. They have a mark that was, I don't represent them, but I've been watching this a little bit. They have a mark that they stopped using and they said they're no longer associated with, but some campus groups or fraternities started trying to use this dead mark that they no longer had federal trademark rights to, and they have expressly said they don't want folks to use it and that they are not going to use it. And then they reached back around and they were like, oh, wait, no, we want to be able to keep, no, that's ours. Probably can't do that after 20 years of saying that it has no association with you anymore. Likelihood of confusion. Generic or merely descriptive. Obviously, if we are past incontestability, this isn't as big of a concern, but we're still always worried about genericide. We are still always worried about which my favorite, and I saw that they were speaking in another panel, the Velcro team did the video about don't say Velcro. You need to make sure that your mark and your clients don't become so famous that their mark becomes generic, because that's a reason for cancellation. Failure to function. Sometimes trademarks do get through. This is a multi-step concern, I think, that would have to be counseled against. And we'll talk about this a little bit later as well. But maybe the mark was filed under a certain class of goods and services, and they're no longer using it for that. But they decide, oh, we just want to use it on our office stuff or on our mugs or whatever. And that way we're still using it. They're not still using it in the class of goods and services that it was originally being used. They're just using it as decoration or for nostalgia purposes. So therefore, that would be something that you may be able to get a cancellation on, or someone may be able to get a cancellation against you. Fraud. And when we talk about fraud and cancellations, USPTO cancellations for fraud, you need to keep in mind that when we plead fraud, we need to keep in mind the civil procedure, federal rules of civil procedure for pleading and proving fraud. A lot of times we will see in infringement or in cancellation proceedings, I should say, you will see allegations for fraud because of the benefits that come with a fraud claim. You may be able to get more money, more attorneys fees covered in ways that you may not before. So you'll see those fraud claims, but it is actually pretty difficult to prove fraud unless it's actually fraud. So whenever you're pleading fraud, make sure you do that with the particularity that they require. Or if you're being attacked for fraud in your application filing, you need to remember that, okay, people who are alleging fraud must plead it in a very particular way and with that specificity that is required. Then everybody's favorite, latches. Just I don't know anybody who says latches and thinks about latches without kind of just being like, latches, here we go. But failure to police your mark as well. So these are the things that we need to be thinking about in those cancellation proceedings, whether we are instituting them in the middle of one right now, or whether we are having somebody file them against your client. The next thing I want you to think about are specimens. This was originally supposed to be a discussion roundtable. So I do want people to kind of pop into the chat. And if anybody from Alt is there and wants to put these, drop them in the big marker for me, I would love that. But thinking about what specimens we're using and in what context we're using them, depending on the technology that is available to us at the time. So think about this. Litigation for trademarks may occur many, many years from now. If hopefully, we're going to hope, and we want to prepare our clients that if their brand does well, which we always want to be looking for, we want to encourage that. We want them to do well. Their brand may exist 50, 100 years in the future. Think about brands like Hershey. Those brands have been around for a very long time. But we need to think about, okay, well, what specimens are going to be the most useful for somebody 50 years from now, for somebody 100 years from now? And this goes hand in hand, with, let me see if I can find it, with this kind of idea that social media specimens have found a place in our trademark applications. I know that we are collecting for social sellers. You will collect Instagram posts. You will collect things for Facebook groups and collect selling on Facebook or other forms of social media. If you represent adult actors or actresses, you may be using platforms like OnlyFans. I know that this sounds a little bit crazy, but there are a lot of very profitable ventures on a platform like OnlyFans, and they have started to protect their brands as well. So we need to be thinking, though, if I'm only submitting this screenshot from OnlyFans, is somebody in 10 years or 20 years, are they going to know what that is? Is it going to make it easy for the fact finder to see or to determine, oh yeah, this is what this was, or oh, I see that this was related to selling because of X, Y, and Z. It may not be the case. So whenever we're thinking about the specimens that we are providing, we need to think about the technology as we move through technology, because things are so rapid. Think about the way that technology has progressed even in the past 10 years, 20 years, 15 years. Do you think that a lawyer maybe in 10 years from now is going to know what a MySpace page is? Probably not. So we need to be thinking about that when we are submitting our specimens, and we need to submit specimens that are going to help our clients in the long run. For litigators, if you are a litigator, what I'm going to try to do is I'm going to try to pull up the the CLE. Okay, so I pulled up the chat. This is great. All right, I can see you guys. This is awesome. All right, litigators. If you are a litigator, I'm trying to integrate everybody in the chat with this, and we're going to try and actually have a conversation here. So if you are a litigator, can you drop in the chat what specimens you have found to be the most effective in litigating either a cancellation proceeding or against a cancellation proceeding, an infringement proceeding? What has been the most helpful to you, and what specimens do you find that you rely on more? This is a little weird with the delay, but we're rocking it. We're gonna make this happen. I'm so pumped. All right. So I am seeing people visiting their GeoCities pages, people asking what OnlyFans is, people asking what MySpace. Okay, cool, great. If you are a trademark okay, so Laurie says the simpler the specimen, the better. Agreed. So maybe don't print out huge long web pages that have kind of do the print screen and have really, really long tables that may be out of kilter. Make sure, I know that sometimes when I go to print screen, web pages look terrible. If you are a trademark practitioner and you are simply a transactional filer of trademarks, you don't litigate, drop in the chat how you decide which specimens to use. And I know that for some of us, it's like, whatever I can find, whatever makes sense, whatever has the buy now button on it. But just kind of think through that as well. And if you have any really good ways to figure that out, just drop that in the chat for me. All right. So MJ Williams is saying that when a mark is used in connection with the goods, a photograph of those goods imprinted with the mark on its packaging or on that physical object is very, very helpful. We also have for goods marks affixed directly onto the goods. We also have people saying, Leah has seconded MJ about photograph of those goods imprinted with the mark on its packaging and that physical object. So it looks like for our physical objects, having the thing with the mark on it. A little picture of the t-shirt or good with the hang tag. That's what sounds good. For services, this is something that I wanted to see too. Company websites clearly indicating the services in the advertising. For pornography services, which if we're already here talking about OnlyFans, something or anything that doesn't have genitalia or sometimes redacting the bits. Got that. Try to go for multiple specimens affixed to goods and pages where the goods can be bought. For online stores, product packaging. Whatever the client has available, and you handle any issues as they arise. Yeah, sometimes you're just trying to figure out what the client has on hand and what you can actually use to get that in. Screenshot of the website. I work with a lot of clients that provide tech services. I do too. I do a lot of screenshots of websites. I do want to remind people, if you are using Chrome or anything that has your picture in the up-hand corner, maybe use the incognito tab, because I know that before I realized that my picture was in an icon on the upper hand corner of the specimen submission. I now realize that my face is on tons and tons of submissions at the USPTO, unfortunately. All right. It's imperfect, but gets us started. Yes, Daniel, agree. For multiple goods, I prefer to show examples of each. Not necessary, but helps later on demonstrate use when somebody tries to slice and dice the goods and services and allege fraud. I really love this example from James. This is a fantastic example when you have somebody later in the game who's trying to say, okay, well, maybe your mark is getting attacked and somebody's saying, okay, well, maybe they do have a trademark for this, this, and this, but they didn't file. They can't say that they have a trademark over, maybe they have A, B, and C, but they can't say C, D, and D. That shouldn't be in the application. If you have pictures of the specimens in that application, that's going to be really hard for somebody to allege. So I really love that. I like overkill on the specimens. I know that sometimes we don't have a ton and we're just trying to get that application in, but I'm a huge fan of submitting a lot if you can. All right, let's see. Oh, for bars and restaurants. This is cool. Frontage sign of the establishment. Love that. That's really good, because that's also really hard to say that that's a fake image. I know that with a lot of the t-shirts and goods and items, sometimes you get people alleging it's a fake image or it's an altered image. So that's really good. What are people doing for, okay, we're going to skip that for a minute. Invoices for services. All right. Ed says, Ed, who is super knowledgeable, follow him on Twitter because he drops a lot of good stuff there, may be helpful to think, would I be inclined to refuse this evidence if I were a trademark examining attorney? Would I find it persuasive? And that's a really good point, because if you watched one of the examining attorneys yesterday, or that they probably went through a lot of all that. All right. So let's move on a little bit, because I want to make sure we get through all of this. All right. But thank you guys so much. That was really, really helpful, I think, to everybody to see what everybody else uses and how we can actually make our specimen submissions, say that 10 times fast, better. All right. Facts. Let's talk about facts, guys. Facts, obviously, can be very crucial in an application. Applications under Federal Rules of Civil Procedure can contain these facts not subject to proof. So there are things that when you are in litigation, the facts don't necessarily have to be proven, and examiners or judges who are maybe ruling on 12b6 motions, they can look outside of the pleadings to those applications, and you don't necessarily have to go ahead and like prove all those things as true. They're facts that are just kind of taken as true. So if you are not a litigator, this is very important, because you don't have to go through the whole rigmarole of showing it all, and it's it can be very, very helpful. And I know that when we are looking at first use in commerce or first use period, those can be, at least when I started practicing, I didn't realize how critical those were. And I want to be completely transparent and not put on any airs that I'm like immune from doing all of this, because I think that when you're a younger lawyer or a newer trademark practitioner, you make mistakes. And so I didn't realize myself even how important it was to really, really nail those down and get as close as possible. So when we are thinking about those first use and use in commerce, how do we figure that out? How do we impress upon the client how important it is to tell us right when they first sold their first thing? Or how do we figure out when they actually did sell their first thing, or when they actually did use it for the first time? Because if we're dealing with brands that are a lot older, they may not have those records. They may not know these things. We have to do our due diligence as attorneys. We can't just, slap on, oh, it was this year, because I know that that's an option. If you if you know a general time, you can put 12/31 of that year, but that's not a great option. We don't want to do that. That's not serving our clients well, and that's not prepping for the future when, if they're challenged, maybe somebody at the same time or in the same year started something called a very similar, confusingly similar name. So dates of first use are obviously crucial. What are some ways, back in the chat, I'm looking over here again with you guys, what are some ways that we can verify or discover those first use dates? And what are some ways to verify or discover first use in commerce? Because obviously those are different. We need to figure out how to A, identify which is which, and B, make sure that we can not only find them, but we can actually support those if need be. For me, I really like these options. And please, again, feel free to drop more in the chat. I know that a lot, Wayback Machine, yes. I know that there are a lot of people who probably have their own methods to figure this out. I love the Wayback Machine. The Wayback Machine, for those of you who don't know, it is a way that the internet is archived, essentially. There are little crawlers that go through and take screenshots of things. It's not every day. It's not every month. Sometimes there's no rhyme or reason, but it will go through and catalog the way websites look on certain times. So you can put your applicant's website into the Wayback Machine, and you can go back as far as you can and see what's there on what date. And that way you at least have some sort of hard evidence that you're saying like, okay, well, I know that on this date, it looked like this and that they were selling it and that their cart was open or that they had the ability to sell this good or service because here is the hard proof, here's a screenshot, yada, yada. Also, who is data from ICANN? This isn't good for first use in commerce. However, this could be good for first use if they are not sure when they first started getting domain names, when they first formed their, put their website live. You can maybe go into who is data, figure out when this was all filed, and you'll have some support there. You can also, this is pretty easy and this should be obvious, although those of us that work with small business owners, you know that they don't always do this on time or do this within the first year or do this before they talk to a lawyer, but your SEC records, your state corporations division databases, they are going to be good evidence of when they started their company, although we know that a lot of them have probably been in business for a little bit before they actually started or filed their LLC paperwork. But again, if we need evidence, if we need support, this is where it is. Your online sellers like Shopify, WooCommerce, Amazon, Venmo, Etsy, PayPal, you can look at those. It's great because they are going to log the first sales. Their first sales may not be online, but if they are online sellers and in an increasingly e-commerce heavy world where people are selling on Instagram, selling on social, you have brands popping up and becoming popular just over Instagram and a Shopify website, and now they are going to be multi-million-dollar companies in weeks. We've all probably seen it happen with some brands. You can go on their websites and kind of dig through and you will have really, really great records of those transactions. So again, if they are using those platforms to sell, you will have that. However, we do need to counsel clients. Again, they may not have come to you first, so you may not have had the opportunity to do this, but we need to counsel clients to make sure that they are not constantly switching platforms, etc. I'll talk about that a little bit in a second, but to be keeping their platforms open and not just closing out their accounts necessarily. If you are working with somebody who provides maybe consulting or group coaching or has a program that they are looking to trademark the name of, look at their Facebook page or their Facebook group page, and you can look at the about section of that page, because it will tell you when that Facebook group was created. And if they are in that consulting kind of group coaching realm, or maybe they are just somebody who has created a community for people that like their product, etc., you can do that there. Also, just if it is a brand Facebook page, you will be able to find when that brand page was created as well. You can also look back to when certain payment apps or Shopify or any sort of online sales was connected to that account, because you can sell through Facebook now. So looking at those dates will also be helpful for a first use in commerce date. So also good for first use and first use in commerce. Remember though, platforms change, software changes, and data does get deleted. We talked about this a little bit before, where people may be bouncing from platform to platform. Platforms become obsolete. MySpace, we don't use it anymore. So what you need to do is you need to counsel your clients. I think somebody also said this before in the comments. You need to be counseling your clients that they need to save these things, and you also need to save these as well. So maybe you are not necessarily submitting all these as specimens, which I would submit everything you have. But if you're not submitting everything, maybe it's a little bit of overkill. You want to make sure that they're keeping these examples in a safe place. Maybe they're print screening. Maybe they are doing screenshots and sending them to you. Maybe you're checking in with them every so often to get screenshots or to get examples of use in commerce or tags or things of that nature. Or every time they maybe update their logo, maybe not enough to cause problems with the USPTO, but maybe they are updating it to the point where we need to start looking at it and say, hey, these are not minor changes, and these are changes that you're going to be required to file a new trademark application because your logo is changing. It can't be, tacked on. You need to be in constant communication with them about this. And I think that if we go back to the first dates of this conference, the panel on subscription services, I think this is a really great place to keep in contact with your clients and to implement that subscription service. So trying to tie everything together here. I see Francis has asked, I usually submit one specimen. Are you suggesting we submit more than one? I didn't know that was possible. Thank you. Yes, I definitely advise to submit more than one specimen. Really, you just go into that specimen upload and you just upload a couple. If I think it's especially going to be contentious, or there are lots of different types of products or goods and services under the same class, or they're maybe a little bit different, I say throw them all in there, whatever you have, because it's kind of like, I believe that you want to give them as much, any sort of person who's looking at this application, you want to give them as much reason to believe your application. You need to give it to them. Make it as easy as it can be for them to decide in your favor. That's something I tell clients a lot. We want to make it as easy as possible for a judge, for a fact finder to decide in our favor. Maybe it's TTAB, who knows? We want them to have a very, very easy time. We don't want them to have to dig around to figure stuff out, right? So the more you can give them, the better, I think, at least. All right. Now, so that's a good point. Robert said, TEAS requires individually upload each specimen, no batch uploading. You do have to submit them one at a time. So like maybe you have 10 PDFs, or you have like 20 products and you have PDF screenshots of all 20. You have to upload them one at a time. You can't just be like, all right, here's my big old file folder of them. Just kind of. It's also a really great way to avoid office actions. If maybe you messed up on one of them, maybe it's a screenshot of a website and you don't have the date and time or the URL or something. It's a way to make sure that you don't have to deal with an office action as well, because you've submitted a bunch of other specimens that are perfect in every way and are admissible. Or they are acceptable to that trademark examiner. All right. I'm going to keep moving just because I want to make sure we don't lose our time here. Okay. Utilize every avenue. This is really important if we are trying to avoid litigation. I do want to kind of divert our conversation here because we want to avoid litigation whenever possible because it's very expensive. I don't think anybody wishes litigation on their client, right? Like whether you are trying to go after infringers or you are dealing with getting accused of infringement, we don't love it. It's expensive. So several organizations are going to hold a lot of power over commercial activity. And obviously Amazon's one of these. We have Etsy, we have YouTube, Instagram, Facebook. Those are kind of our big players. You can also look at smaller platforms like Shopify. Well, I guess Shopify is not that small anymore, but your WooCommerce, things of that nature, or other selling, Kajabi, if you work with course creators or content creators. Sometimes just working with those entities you can avoid litigation, period. And that doesn't necessarily mean you will always be able to avoid it that way. But if we are trying to be judicious with our clients' funds, because funds are finite, and whether you are a massive, massive organization with hundreds of millions of dollars in revenue, or you are a small company, we do have legal budgets, and we have budgets that we have to stick to. So utilizing avenues outside of litigation before we actually get into litigation can not only be cost efficient, but they also make you look better as a enforcer of trademarks, because you can say, we tried everything we could. Judge, we didn't want to bring this infringement action. Judge, we didn't want to end up here, and we tried everything we could. We tried DMCA takedowns. We tried negotiating. That makes you look better, because obviously judges don't love it when everybody ends up there for whatever reason. They want you to be able to, they don't love when you just file an infringement action out of almost nowhere. Granted, nobody's not going to file a cease and desist first, probably, but they want you to exhaust every avenue you can. So simply working with these entities, using those takedown notices, discussing, going through their intellectual property avenues, while they are not always successful, those are great ways to help your client avoid filing a lawsuit outright. Oh, I do want to mention too, sometimes when we think about litigation strategy, right, we're thinking about, okay, well, we are going to file a complaint and then we'll get into negotiations. Maybe there's been a little negotiation on the front end. Then you file the complaint to show them you're serious. You can get the same leverage sometimes by filing a takedown, by filing to get an account locked. Because, and honestly, I think sometimes you can get more leverage in this way. You are then kind of stopping a revenue stream for them immediately. It's almost, in practicality, it becomes almost like an injunction, because if you're shutting down their Amazon store, or you are shutting down their social selling mechanisms, or you are pulling their shop off of Etsy because they're refusing to comply with the cease and desist, they're not able to sell through that platform anymore. So you are forcing the conversation you would have by filing a complaint without the expense of filing the complaint, if that makes sense. Oh, here we go. We can force the opposing party to the negotiating table. This is exactly what we were talking about, what I was talking about before. I should have flipped to this slide, but you can create these types of needs to come to an agreement or needs to come to a settlement by cutting off these different mechanisms. All right. So let's talk about considering how we can draft an application to put our client into the strongest position. We're switching gears. How do we help them when we are dealing with organizations who might not understand the nuances of likelihood of confusion? This is a hard question, and I wanted to pose this question, and honestly, for me, I don't have the straight answer for this. This is something that I wanted everybody to talk about in this roundtable. So let's talk about it in the discussions. How do we draft an application to put a client in a stronger position when dealing with organizations? Maybe they're social sellers, maybe they are small first-time brand owners, maybe they are Etsy stores, maybe they don't understand that a likelihood of confusion analysis is based on not on a exact match to the trademark, not like a social handle or a URL, because that's what we've all been conditioned as individuals, as lay people. You think with your lay people brain. We have been conditioned to think, oh, a URL is not available, I'll just get it in the .co, or oh, a URL is not available, I'll just add an S to it. That is how a lot of social sellers or less sophisticated individuals are operating when it comes to trademark. Maybe they have not had any exposure to trademark law. They think they're doing fine, But this still creates a situation where we as counsel to our clients have to counsel them, okay, well, you need to be policing your trademark rights here. This isn't going to fly. You have to now spend money to deal with this problem. I will give you an example from my own life. I have a client right now who we have a established trademark. They've had it for the past, I think, 10 years. There is someone in the exact same class of goods and services a couple states over who has come up and they are using the exact same mark, except they dropped one vowel. So instead of it being, maybe biker, B-I-K-E-R, it's B-I-K-R. They, as individuals who have not really had that much exposure to trademark law or intellectual property law, they are saying, oh, well, we're not using the same name, or it's different because we don't have an E. Is there a way that we can draft our applications to explain this? Or is there supporting evidence that we can use to help explain this to unrepresented individuals? Or is there a way that we can help maybe save money for our clients in dealing with these types of things? And I believe that when we are dealing with individuals who are not represented or who are maybe newer to business and newer to intellectual property rights generally, dealing with them can be more expensive than actually dealing with people who are represented. Because if people are represented, they're getting the counseling that they need to understand, hey, you actually can't use this. If you have unrepresented individuals, they will hold on for a lot longer. So just like I said previously, we may need to go through those other avenues. I don't know if you can hear the trash truck outside my home right now. This is the joy of working from home during a pandemic. We may need to utilize those other avenues like the takedowns or like intellectual property dispute resolution through Facebook, Instagram, Etsy, Amazon. So making sure your trademark application is very thorough in showing that all the goods and services that you provide, I think, is a good way to do this. So not just saying, hey, Amazon, here's my trademark application that I filed with only one of the goods or only one type of the goods, when the other person, maybe they're selling in your same class of goods and services, and they're selling similar goods to you, but maybe you don't have those goods represented as specimens in your application. This is a really good kind of circle back to, and I saw there was a lot of chatter in the comments. I was trying not to read them all and get too distracted, but there's a lot of chatter in the comments about whether we submit a lot of specimens or not. This will be a good time for us to consider, okay, more specimens, because submitting those other specimens is going to be helpful if we are trying to explain to a brand like Instagram or to a platform like Etsy, hey, I have rights over this. I am selling this and my trademark covers this. So that might be one situation, because they don't want to be held responsible for taking stuff down if they are in the wrong, because then they can get it. So we want to make it, again, as easy as possible for people to decide in our favor, and to make it as easy as possible for them to go back to, whether it's a social seller, whether it is a small brand, maybe, the new business owner, and say, hey, their application actually does cover this. So we really can't allow you to do this. And that's why we're taking it down. That might just be one avenue that we could take, but that is why I like to submit more specimens. All right, signing our application. We might all know this by now, but I think it is very, very important to discuss when we sign our applications. We need to have our clients do it. Technically, attorneys can validate the application. We can sign the application, right? We are allowed to. However, this is usually not a great idea. Not a great idea for us, right? Why? Let's talk about it. And before we go any further, like I've done this, we've probably all done it at least once. Why is it not a good idea? It's not a great idea because when we sign our applications for our clients, we are submitting a sworn statement that we have personal knowledge of the facts contained in that application. We are saying, I understand and I know everything that I'm saying and I know it's right and I have personal knowledge that they are selling and this is the first date, yada, 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 whether it's their intent to sell or their actual sales. But because these are facts, this may backfire and cause us to become a fact witness in future litigation. And what happens when you become a fact witness? You may be conflicted out of representing this client. Maybe there were problems with the application. Maybe something you say may harm them in the end. So not only is your client stuck in litigation, not only do they have their lawyer having to testify as to facts in the application, but then they have to find another lawyer, which is just kind of a pain in the butt. So let's not do that if at all possible. And let's make sure that we are always, always, always having our clients sign their own applications. So if you have not done that yet, if you are a new trademark practitioner, there is a easy way to do it. You send it to your client by email. It's a pop-up and you literally email it to yourself and forward it to them. The instructions are right there. If you need help with it, I'm sure any of us would be very, very happy to explain how that works. But yeah, there you go. There's a really good point Robert made. Before signing an application, imagine how you would answer a deposition on your investigation of the facts. Yeah, that's a great point there, Robert. Okay. Client counseling. And I saw a little bit of this also being talked about in the comments, but you need to really make sure we are doing the best for our clients and helping keep them out of trouble and anticipating litigation and helping make sure your client is in the best possible place if there is a cancellation proceeding, if they're in the future after they get registered, obviously, if they are in possibly dealing with an infringement action, or maybe they have a registered trademark and they're moving into other areas and maybe they're getting an infringement action against them. All right. We need to know how to advise them. Our jobs are counselors. Our job is being a counselor to our clients. So how do we do that? What do we tell them? How do we counsel them to put them in the best case or in the best position and give them the best case scenario? I'm trying to combine both of those together. I think one of the more important things to do is to really stress the importance of the Circle R. This post-registration counseling, we need to impress upon our clients the importance of using that Circle R in all of their marketing, on their website, on their products. And I know that I personally do get a lot of pushback on the product side because maybe they've already produced a lot of product, or they don't want to do another run of the product, or they think that the Circle R is ugly, which I've gotten from my more design heavy individuals. You need to explain to them why it's very important to use the Circle R, because even if they don't want to use it, it doesn't matter. This comes straight out of the Lanham Act. By such a registrant failing to give such notice of the registrations, they don't get, profits, damages, unless the defendant had actual notice. So unless the defendant in an infringement action actually knew they were infringing. So how do we show that? I mean, after a cease and desist, but unless they knew they were infringing, unless they, you probably can't get anything before that infringement, before you send that cease and desist. And if they don't think they're infringing and there is a good argument about it, like you're probably not going to get awarded that. So we need to really counsel our clients on the importance of using the Circle R and not just the little TM, because we know the little TM doesn't necessarily do what we want it to do. This chat is cracking me up, you guys. I love this. All right, just another quick couple things about post-registration counseling, policing the mark with purpose. If you are a smaller company, if you're representing a smaller company, we need to discuss with them the importance of policing their trademarks, but also kind of the ostrich theory if we are being reserved with our finances. We obviously do not want to stress our clients' finances or put them into bankruptcy because they are policing their trademark within an inch of its life. So what I have told clients a lot of times is to ignore infringement until you can't. Don't go looking for it. If we are in a position where we can't actively police because of financial concerns. If you are working with a bigger brand who is really trying to expand and trying to police their rights and make sure there is not a lot of infringement happening, or they have a concern about their trademark, or maybe it's a weaker mark and they are trying to acquire distinctiveness to that mark, you need to tell them you need to have a stronger enforcement strategy. You need to be going after people, show that you're policing your mark, sending out your cease and desists. I believe that this is what happened recently with White Claw, the White Claw seltzer brand. I love a White Claw, but they have recently begun really, really aggressively policing their mark. So I think that they had a come to Jesus talk with their representation, their trademark representation, and maybe they are planning on expanding into other markets. Maybe they were having some issues with a lot of infringement, which I think they were based on what I've seen on Etsy. And they decided that they needed to actually really start with a strong enforcement strategy. So whatever is manageable for your client, whatever is going to be strategically relevant and financially feasible for them is how you need to advise them. Cease and desist letters kind of go along with this. You need to not only send cease and desist letters, but send cease and desist letters only when you are going to follow up on them. Everybody knows that if you send cease and desist letters and don't follow up on them, that is a really, really good indication that you are not doing your due diligence in policing your marks. So you need to be following up on them if you're sending them. I think I'm going to put on my grave, thou shalt not send a cease and desist unless you are ready to follow up on it. So always discuss with your clients and discuss the implications of sending those cease and desists and why they don't need to be sending those cease and desists without your counsel on that. I also want to stress that you don't have to be a jerk in your cease and desists. We have seen recently, especially in the craft beer industry and in the alcohol industry, that cease and desist can be very fun. They can also be a great extension of the brand. I really would love to chat through this with you. I know you've probably seen these cease and desist letters as they go out, but you can help a smaller brand or even a larger brand stay on brand and not alienate the fan bases they have or the consumers they have by enforcing their mark. I think this is a really, really great strategy. Anybody that may have sent out the fun cease and desists definitely knows definitely look those up. Jack Daniels does a great job. Again, a lot of craft beers. I think Bud Light does a great job with that as well. So you can make sure if you have a client who is not keen on sending out mean cease and desists, your traditional cease and desist, this is a really great avenue to have a good extension of your brand. Make sure your clients understand why naked licensing is bad, what naked licensing is, and if they have sub-entities or maybe smaller entities within their entities, LLCs under their LLC, maybe they are working with a parent company, discussing and putting into place those licensing agreements between the companies so that there isn't a naked license. Because when I go into litigation strategy, one of the first things when we are thinking about document production is we ask for those licenses. Naked licenses is a great way to get a mark canceled, and it gives a lot of leverage. And then also keeping that business information up to date, because you want to make sure that if the company, the LLC, has closed, maybe it has merged with another one of their smaller companies, an LLC, maybe it's been bought out by a parent company, keeping that information up to date is very important so that, again, you don't have a naked license or you don't have an improperly licensed trademark from one entity to the other. Also, if you are registering it on behalf of an individual and it really belongs to a company, so maybe Bob is the sole member of a company, it needs to be registered to the company, not just to Bob. Or Bob needs to be able to have a license with that company to use it, or needs to just transfer that trademark to them. All right. This is my information. I am really happy to discuss this with anybody, or if you want to just chat trademarks, I would love to. I am so blessed to have been able to do this because a lot of my trademark crushes and idols are at this conference. So thank you guys so much for having me. We do have some Q&A time. I see the chat's going crazy over here, so I'm going to scroll back through it. But if you do have questions about some of the things that I just talked about, please feel free to drop them in. All right, I'm going to scroll back a little bit right now. Thank you, Deirdre. Let's see. Okay, so Bud Light C&D, they dropped about the town crier delivery. Yes, if you have not seen that trademark enforcement strategy or that trademark enforcement method, definitely Google that or do a Google search for that. It is very, very interesting. And the more, the smaller the brand that I represent, or not the smaller the brand, the more, because it's big brands too, I guess, that I've been representing, they want trademark enforcement strategies like that. So they don't want to be seen as a jerk or as a trademark bully. So if you are representing folks, definitely do that. Thank you, Elise. I appreciate it. Thank you, Anna. Thank you guys so much. It was a little tricky incorporating the chat, and I definitely caught myself getting a little bit distracted sometimes. So I hope that I was okay. But again, any other questions, please feel free to reach out. I'm very, very grateful to you all. I guess somebody's supposed to come in shortly. Until then, I'm going to go back through and look at stuff. I know Stacy had a really good point from the litigation side that I want to make sure I hit on. Okay, Stacy, yes. Way back when we were talking about specimens. As a litigator, one note on the overkill, adding everything possible for specimens. I do believe in using multiple specimens, but only up to the point something might backfire. You need proof of use with the mark that it's accurate and not deceptive. No less and no more. Really good point. Really good point. I would not want to add too many extras that were not necessary and could have unintended consequences you aren't even thinking of. E.g., client had a web page for services or another company was sponsoring a particular event. First glance, a good representation of the mark in use. The page could have been interpreted as confusing or associated with another company's mark. That's a really, really great point, Stacy. I think that, the everything but the kitchen sink approach definitely might be overkill, but always putting in enough specimens so that you're proving your point and that you are, overcoming that. I think it's, getting the trademark plus, showing use plus, just like a little bit more than you need to be doing. So really, really great point. I like that, especially about if you're in litigation.
Hey, Caroline.
Hey,
everybody. Just wanted to pop in. Sorry about that. My camera was fighting with me, but here I am with the CLE code. It's J like James, V like Victor, the number 8, the number 4, and L like litigators. So JV84L. Thanks so much, Caroline. You're doing a great job with the questions. Keep them coming. I'll pop back in a few.
Perfect. Awesome. Okay. I'm gonna take a sip of water really quick. All right. Here's a question. In regards to applications, is it best to file single class applications with own set of specimens and dates of first use, or multi-class applications are still all right? I think that depends on this. I think it depends honestly on the underlying good and service. If you think there's going to be a problem with one of the applications, sometimes we're trying really hard to just get stuff going as quickly as possible. And if we think there's going to be a hang up with one of the applications, we will file it separately. When I first started practicing, I didn't do this as often, or I didn't do this or consider this as much as I do now. But after being in practice for 7 years, I definitely do this more. And I think if you're working with a product-based business, here's an example of why you want to split them up. You're working with a product-based business. Maybe they really want to get Amazon brand registry status. They want that status as soon as possible. We have a couple different types of products, and we're worried a little bit about one of them. We don't want the application and therefore the Amazon brand registry status to get hung up because of just one of the things. So, I mean, you can always file a request to divide later, but that's more money. I think somebody said that. I know Rebecca mentioned some good points about it. So that's why I would file it. Oh yeah, and then you can often do separate, hey client, here are all your 9 certificates. That's a good point too, because then you have all this work product that you can give them and be like, here are all of the certificates that I got for you. Congratulations. That's fun as well. So, all right. Re-asking. When you provide a specimen to register the mark, if it becomes obsolete, won't that be corrected at the 5, 6-year point and 10-year points? Does every specimen ever registered stay active? So, I mean, you do submit new specimens, but if we're looking back at the original application or they're attacking the original application, that's when I would be a little bit more concerned about those original specimens. And 10 years, if we think about it, in technology world is a really, really long time. So that's more of what I want you to think about when we're thinking about specimens and technology and like them kind of moving into different places. If that makes sense. So, oh, you can ignore. Okay, thanks, Leah. All right, I think that's probably it. We're coming up on time. I know that we got other places to be. Thank you guys so much. I really, really have loved interacting with you. This has been amazing. Thank you for being so active in the chat, which has been fantastic. And if you have any questions, I would love to chat, meet with you, anything like that. You can find me on Twitter. I'm pretty active. Legal Twitter's great. So thank you guys. And I will, I guess, see you guys in the other sessions.
Thanks so much, Caroline. That was wonderful. Really learned so much. This is really helpful about, keeping litigation in mind. Really helpful. Up next, everyone, at 1:40 p.m. Eastern, we have what you need to know about the USPTO's post-registration audit program and culturally relevant representation. Go to the schedule page umbrella to choose which session to attend and join. Thanks so much for listening. That CLE code again is JV84L. J like James, V like Victor, 84, and L like litigators. Thanks again, Caroline, for a great presentation, as always. Appreciate it so much.
Thanks, guys.